Welcome. Welcome to A Taste of Justice. I'm Professor Angela May Kupenda, and solely for informational purposes, identification purposes, I'm a professor at Mississippi College School of Law, but all views and interpretations expressed here are my own and are not to be ascribed to my school. So we've been talking about the three co-equal branches of government. In the last clips, we talked about the federal judiciary. Tonight, we're going to talk about the powers of Congress. And then in the next clip, we will conclude the powers of Congress, talk about the powers of the president, and a doctrine called the separation of powers. So let's get with it. So as we know, Congress is made up of the House of Representatives and of the Senate. You can take a look, you can Google or read your Constitution to read more about the membership in both of those bodies. But the two together make up Congress. Okay, so I want to focus on the three major powers of Congress, three major clauses in the Constitution. One is the necessary and proper clause. The other is the commerce clause and the spending clause. Those are the three you will likely hear more frequently as the powers of Congress are discussed. Okay, so let's talk about the necessary and proper clause. If you take a look at your Constitution, if you don't have one, you can just Google it, read Article 1, Section 8, and you will see many of the enumerated powers of Congress. Remember, Article 1, Section 8 starts out by saying Congress has the powers herein granted, herein enumerated in the Constitution. So if you look at Article 1, Section 8, you will see some of those powers. If you look, for example, at the Reconstruction Amendments, we've talked about the enabling provisions. You will see others of the powers of Congress, and you will see other powers throughout the Constitution. But the three major ones that we want to talk about are the necessary and proper clause, which is Article 1, Section 8, Clause 18, the commerce clause, Article 1, Section 8, Clause 3, and the taxing and spending clause, Article 1, Section 8, Clause 1 of the Constitution. Okay, so what's with this necessary and proper clause? And why am I starting with the final one listed in Article 1, Section 8? The necessary and proper clause is very important. The necessary and proper clause arguably expands the powers of Congress beyond what you see in the text. So it is very important in terms of the reach of congressional power. So let me give you an example. So many years ago, and I have my notes just so I'll stay on track. So many years ago, long time ago in 1819, Congress decided that it was going to establish a federal or national bank. Now, if you look in the enumerated powers of Congress, if you read the whole Constitution, you will not see anywhere that expressly gives Congress the authority to establish a national or federal bank. So a state said, we don't have to recognize this federal bank. And then the state said, and if we do, you're going to have to pay a tax to our state. So the case is McCulloch versus Maryland, and the case is noted. Don't forget about the text below the video where I list these cases and their dates so you can look them up and read for yourself and check me. Just like the co-equal branches check each other, check me to make sure that I got it just right. So in this case, Congress says, oh, we got the power. We got the power to establish a federal bank. Congress's argument was a bank is helpful. A bank is needful, a national bank, because we're managing this money we're collecting from taxes. We have the spending power, we're spending on the military and what have you. So therefore, a bank will be helpful. But the state said the necessary and proper clause said that Congress can only do what's absolutely necessary. And having a national bank, according to a state, was not absolutely necessary. Well, the court sided with Congress. The court said, look at the necessary and proper clause. It's there with the powers of Congress. The court said there are different ways of looking at necessary. Something can be absolutely necessary, somewhat necessary, or helpful. Look, I'm not making this stuff up. You read that case and see that I am correct here. And the court said that a bank, even though it is not expressly listed, Congress does have the authority to establish a national bank because it is helpful to carrying out its other powers. So this was sort of the beginning of this expansion of the necessary and proper clause. And some people would say it wasn't an expansion, it was just the court's interpretation of what was there. Now, what about the tax? Could the state tax the bank that Congress established? The court said, no, you can't. The power to tax is the power to destroy, according to the court. And maybe some of you on April 15th of each year, right? Okay, I'm just messing with you. But the court said that no, the state cannot tax this bank. But we see that Congress does have powers other than the powers expressly stated in the Constitution, because the necessary and proper clause means Congress can do other things than the expressly noted powers if it is helpful, needful in carrying out the powers that are noted. Now you're probably saying, say what? Say what? Oh yeah. Well, let me give you another one. The case name is U.S. versus Comstock, and it's mentioned below. So there was a federal prisoner who had served his term. The federal prisoner had a mental illness and was regarded as being very dangerous. The Congress tried to get his state to take him, but the state declined. So the federal government decided it would continue to detain the prisoner after the prison term was over. And the question was, can Congress do that? And the court said, yes, Congress can. Congress, the necessary and proper clause, this is what the court said. Congress has some specific powers. Following those powers, Congress has been involved in federal law enforcement. And so now the authority to detain a federal prisoner past his prison term is connected to some of the other things Congress has been doing pursuant to their enumerated powers. Of course, there was a dissent said, What? The necessary and proper clause means there's a direct connection to a power. Here you're spreading it out even more. But that was the dissent. The court approved that use of congressional power in U.S. versus Comstock, and that is a 2010 case. Now let's do just a little aside point here, and a side point as related going back to the McCulloch case about the bank. There is a statement in that interpretation, what the court is ruling, and the court said, in considering this question, we must never forget that it is a constitution that we are expounding. Now say that to someone. It is a constitution we are expounding. So what does that mean? For some people, it is a constitution we are expounding. It means that our constitution is a living, growing instrument. And when the court interprets the Constitution, the court must see it as a living instrument, and we look and see what are the current needs and tendencies in society, and therefore the Constitution changes as generations, as mindsets change. But for some people, it is a constitution we are expounding. It means that we should stick to the strict text of the Constitution. And if the people do not like the strict text, they can follow Article 5 of the Constitution and amend it. But otherwise, it is a constitution. We stick to the framers' intent, we stick to the text, or do you take another view that you look at the spirit of the Constitution? And the Constitution must have flexibility. You decide, and you debate that with your family and friends, but you'll find the language in the McCulloch case. Now, that was the necessary and proper. Necessary and proper clause then can be added to other powers of Congress, and also can be added to Congress had a power, they employed something, and something is necessary and proper to that employment or to that principle. So the necessary and proper clause enlarges the powers of Congress beyond what you see in the text. So let's look at another one. Let's look at the Commerce Clause. The Commerce Clause is found in Article 1, Section 8, Clause 3 of the Constitution. So a major source of congressional authority is in the Commerce Clause. Google and take a look at it. But it provides that Congress has the power to regulate commerce with foreign nations, among the several states, and with the Indian tribes. Now, as to the Indian tribes, there is a whole nother body of learning about Native Americans and the law. And in my civil rights lawsuit course, I also mentioned Under Ripples of Hope, that final clip, a book that is so amazing that will teach you more about what Native Americans were experiencing as they were attempting to negotiate with the government here. So here we're going to focus in on the part of the Commerce Clause that says Congress has the authority to regulate commerce among the several states, among. And there's a whole case that discusses what the word among means. And I ask you, what does the word among, A-M-O-N-G, mean to you? So The case was Gibbons versus Ogden. And the question was, who would get to decide in terms of some authority to navigate in a particular area? Would it be the state or would it be the federal government? And in that case, Gibbons, that's noted below in the notes, the court says that the Commerce Clause is really important in our being able to act as one nation. So if you have one state here and another state here, the court says among doesn't just mean on that straight line, that that's the only place Congress can regulate on the line, on the boundary. The court says that among means Congress can step into a state, that Congress can step into the boundaries of states in order to regulate. And that was just one of the first cases that gave the Commerce Clause some more expansive reading, or maybe you would say it was appropriate interpretation or broadened the power of Congress in a follow-up case. And I've noted all of these below, so you can go look at them for yourself. The court said that Congress could also regulate the unfair labor practices of a steel producer. How did Congress get to do that? The court says that it could affect commerce if you had a number of different producers with these unfair labor practices. It could end up impacting commerce as a whole when all of this cumulative effect is added up. So the court said Congress not only could step into a state, Congress can also step into private industry and regulate it. But then it went further. Congress was really concerned about establishing a minimum wage. How can they just establish a minimum wage? And someone said, through the commerce power. But then in the case U.S. versus Darby, the company said, how is Congress going to do this? Their motive is not about commerce. Their motive is about setting a minimum wage. And the court said, motive doesn't matter as long as it touches on interstate commerce. Congress can do this. And then a case that a lot of my students tend to have problems with. This case, well, not because they don't understand it, because they do understand it. The case is called Wickard versus Filburn. Now, in Wickard, Congress was concerned that there was an overproduction of wheat, and therefore the instability it may cause in the markets. So if you grew over a certain amount of wheat, even if it was for consumption on your farm, a person had to pay a penalty or a tax. And so in Wickard versus Filburn, a farmer for his own use on his farm grew more wheat than he was told he could grow, and he was supposed to pay a penalty. So he brought suit and said, this whole scheme is unconstitutional. What does commerce have to do with what I'm doing on my own private farm for my use on my farm? And the court said, what Congress is doing is constitutional. Because this, you may say, is just about you, but what about the cumulative effects on commerce? And so therefore, Congress has power to regulate the amount of wheat the farmer was growing on his farm, even for his own purposes. Now, Wickard is still considered to be good law, but it is called, get ready for this, the outer limits. This sounds like the Twilight Zone or something show. Wickard is considered the outer limits. So we have the text of the Commerce Clause, and it looks like that power grew. And the court said, but here's Wickard. Wickard is the outer limits, Congress. You're not going any farther than this. And the court continues to say that Wickard is the outer limits of the Commerce Clause. Now, that's the outer limits. We want to talk about a case that's within the limits. Now, I got to ask you some review questions. Do you remember way back when we first got started, we talked about state action? Do you remember? Do you remember? And we were talking about a case called the civil rights cases. You remember? One of the dissenting opinions was a justice who was a white male who had owned slaves at one point, but he had a half-brother who was Black and was a slave. In the civil rights case, this was way back in the late 1800s, right after the end of slavery, Congress wanted us all to be able to function together as one nation. So Congress passed a law and said that private racial discrimination in businesses open to the public were unlawful. You can't have an open restaurant and say, y'all come, but not y'all Black people, right? So Congress passed this law, but then the court struck it down. The court said, this is not about slavery. This was in 1883, and it's not the government, it's private business. But then the court dropped a line and said, if you had made it more about money, maybe so. But here you didn't do that. So no. Well, after that case, private businesses continued to discriminate against people racially. Then we had Plessy versus Ferguson saying separate and equal is constitutional, and we know a lot of it was separate and unequal. We then had the civil rights movement. We had a lot of people who sacrificed, some even with their lives, to try to bring us together racially as one country. And so Black people could go and sit down in a restaurant if they choose and dine in a private restaurant. Now, the Congress then passed the law. Congress passed the law, the president signed. It was called the Civil Rights Act of 1964. And so we have this act now that private businesses must allow Black people to be served or what have you if the businesses are open to the public. And there is a challenge. At the bottom, I mentioned two cases, Ollie's Barbecue and Heart of Atlanta Motel. Ollie's Barbecue said, oh, Black people can come here, but they have to go around back. They have to go around back and get it to go. And Congress, you can't make us let them in because most of our business is local. Our business is not really interstate. So the question is, could Congress regulate based on the Commerce Clause? And the court held that Congress could. And the court held that the Civil Rights Act was indeed constitutional. Now, I want to tell you a little story about myself. And when we were traveling from Mississippi up to Tennessee, we had a copy of the Green Book. This is before this case, or maybe after it even. there was massive resistance to much of the civil rights legislation, just like to Brown and other things. So my auntie had the book to try to figure out where we could stop along the way. And my mother decided that she would just pack us some boxes of food, the little shoe boxes. You put in some chicken or some sweet potato pie or a sandwich. And she told us that we could not drink water, or we couldn't drink much water because there would not be anywhere where we would be allowed to use the restroom in private businesses. So on our way though, someone had to stop, someone had to go. We had to pull off the highway, and my mom took us into the high grass in order to use the restroom, to urinate. So that I thought about that in looking at this case of Ollie's Barbecue and Heart of Atlanta Motel, and the court upholding this act so that people like me, wouldn't have to go. That grass was itchy, to go into that grass to try to take care of my needs instead of going into a store and being able to buy something and also asking to use the restroom. But even after the court upheld this act, there was still pushback. There was still massive resistance. Like when I was, I guess in my 20s, it was in the late 70s, the early 80s, I used to travel quite a bit for school and work. And I got tired of going to hotels with a vacancy sign, and they would not allow me to have a room. And sometimes I would stay around to see if the whites who were in the lobby were being given a room when I was told there suddenly were no rooms. So I remember one night I was trying to find a room, and I went to a payphone before cell phones, and I called the hotel. You have a vacancy sign, do you have a room? And the hotel said, yes. And I said, do you rent rooms to Black people? I'm Black. And the hotel said, we have to. It's the law. And I said, I know it's the law. I just want to know, do you follow it before I drive all the way up to your hotel? So these issues about the Commerce Clause, I'm just wondering about if it's going to pose some current constitutional conflicts, because there is massive resistance to other things. There's massive resistance to same-sex couples, to unmarried couples. And for example, there are laws in some states that would allow private businesses to discriminate. So perhaps it's a current constitutional conflict how the court would address those issues when they make it to the court. But before I close, I do want to mention to you that these cases show that we had the text of 183, and then it appears that the text of 183 was expanded to the Wickard case involving the farmer. The court says Wickard is the outer limits of the Commerce Clause. We're not going past there. Then we saw that put into place in two cases that are mentioned at the bottom, Morrison, U.S. versus Morrison, and U.S. versus Lopez. In U.S. versus Lopez, Congress had passed a law saying that near schools, it would be a gun-free area near schools. And the court said, you've gone too far, Congress. How does your commerce power allow you to restrict guns within states in the vicinity of schools? Now, I don't know if we're going to have a current constitutional conflict now, given the increase of gun violence and as related to our schools. But the court said that Congress went too far with that act. And then in Morrison versus US, it was a case involving the Violence Against Women Act in terms of the discrimination, the violence that women may face when they travel. And the court said in that case, Congress, you've gone too far. The court said that Congress has power under the Commerce Clause if it's a national problem and it relates to the channels of commerce or to the instrumentalities of commerce, or it is things in commerce, or it is substantially related to interstate commerce. So the court said that a portion of that act was unconstitutional. The court treated gender discrimination in a different way than it had treated racial discrimination in Ollie's Barbecue and Heart of Atlanta Motel. So I'm wondering if we're going to have a current constitutional conflict involving those issues too. So we have one more clause, the spending clause, but I think I'm going to save it for the next clip and combine it with presidential power and separation of powers. There are so many current constitutional conflicts as to the authority of the federal government, the authority of states, individual rights, and even conflicts between the co-equal branches. There is so much to learn about and to debate and learn and share with your family and friends and other networks. Learning is a path to justice. My goal is to give you a taste of learning about the Constitution and set you on the path to a taste of justice. Subscribe, sign up for notifications, and I'll see you next time. Thank you.